Well, howdy there, folks. James, Political Friar, coming to you again. I'm sorry about the long layover. Mrs. Political Friar had some travel plans, and I didn't really want to record from a hotel room again. I didn't think that was a good look, and so I just decided to hold off and jump back in. Now that I'm back at the home base, and so I got the law hat on, as you can see, and you probably can guess what we're going to talk about. It's the biggest story that happened since I left. It was the Colorado State Supreme Court disqualifying Donald Trump from their ballot on the basis of the 14th Amendment, Section 3. We've done video on this, and I've gone through the basic legal questions already. And so, to prevent myself from repeating, I'm just going to give a couple of notes about this decision and a little bit about the way that this decision came about, because I think there's some political observations to be made about that. And then I'm going to give you a little bit of a legal analysis at the end, in particular, what we can learn about the dissents in this decision. So, first off, the Colorado District Court, the lower court, actually held in favor of Mr. Trump. The judge at that level said that the Section 3 doesn't apply to presidents, basically. He looks at the text of the language and it says senators, House members, electors, and other officers, which, when you're using that type of statutory interpretation, you have the specific senators, and then you have the general, but the general, under her interpretation, was lesser than, which means that a higher ranking official, like vice president, wasn't included in the framers of 14th Amendment Section 3. That conclusion was overturned by the Colorado State Supreme Court, and in their mind, other officers of the United States does include the president and vice president. And so that is the legal conclusion that they came to, and then they were in line with the lower court's legal conclusions on the other issues. For example, that Section 3 is self-executing, doesn't require an act of Congress to come into effect, that it applies to Trump's oath. Some clever people who have bent the law pretty far say that Trump didn't technically promise to support the Constitution, so he's off the hook. Yeah, methinks thou dost protest too hard on that one, and so does the Colorado Supreme Court. They also didn't meddle with the findings of fact that the judge made, that Donald Trump engaged in the insurrection on January 6th. And those two findings of fact are absolutely critical. You have to find that an insurrection occurred and that Donald Trump engaged in it. And the Colorado Supreme Court didn't meddle with those conclusions. And so they basically took the conservative legal scholars' law review article from earlier in the year and turned it into a Supreme Court decision. Now, this decision in Colorado was a 4-3 vote, but it wasn't as close as it looks. The best thing to do when you're looking at a really fresh bit of law, something that is been litigated really for the first time seriously, is to find dissents and read those. See why the dissenters don't like the actual interpretation. And here we have 3 dissents who don't like the interpretation of the majority for various reasons, but not necessarily the reasons you think. See, the 3 big legal issues that are Trump's defenses is that the 14th Amendment, Section 3, isn't self-executing, that it doesn't apply to the presidents, or that Trump's oath doesn't bind him to it. None of the Colorado dissents took those legal opinions. All of the justices, all 7 justices on the Colorado Supreme Court, agreed the 14th Amendment, Section 3 is self-executing. It applies to presidents, and Trump's oath binds him. The dissents for various other reasons. First dissent says Colorado state law envisioned a dispute such as this one coming up in the context of a candidate's age or their citizenship status or some other clearly and easily identifiable fact, and the more difficult facts to establish, such as whether an insurrection occurred or whether one engaged in it, meant that the Colorado state law statute didn't empower the court to have this proceeding. That's the first dissent, saying that no, Colorado state law could do this, but the proceeding that was actually used in this case was inappropriate for a 14th Amendment Section 3 dispute. The majority says no, that's not right, because just like age and other things, the court is empowered to find facts. And, when it's trying to establish somebody's age, they'll maybe look at a birth certificate. They're still finding facts. And the finding of fact of an insurrection or engaged in is of akin nature. The first dissenter disagrees. He says, no, those facts are too hard, and Colorado state law doesn't allow you to bring that. But again, he doesn't say that the 14th Amendment doesn't exclude Donald Trump. He says that Colorado state law didn't provide a remedy. That's not a rounding denunciation of the majority's legal conclusions. It's frankly a technical reason. Now, technical reasons matter in the law, but it really isn't addressing the big issues in the case, and neither does the second dissent. The second dissent says, hey, for facts like finding an insurrection occurred or that Donald Trump engaged in that insurrection, more procedural due process is necessary in all fairness. This judge makes a dissent that basically says there wasn't enough of a trial. There wasn't enough of a process for Donald Trump to have this severe consequence of being removed from the ballot. And so on a procedural due process grounds, he finds that this decision can't go forward. Not that you couldn't do it. For example, if you had a jury trial, if you had full discovery, if you had more process, then this second dissenter agrees that Donald Trump could have been excluded from the ballot. That is to say that those three big legal arguments, this dissenter agrees with the majority, just like the first dissenter agreed with the majority. And the third dissenter also agrees with the majority on the big legal questions. The self-executing applies to presidents, applies to Donald Trump. This third dissenter says, the law didn't authorize the actual litigants to bring suit. It says that the Colorado law envisioned a voter bringing suit on, again, a clearly and easily discernible objection such as age or citizenship status, not on a 14 Section 3. It's really the same flavor as the first dissenter. They read similarly. They make a technical legal argument about state law, not the Constitution, to say that this was not the right procedure, and their remedy would be for the Colorado legislature to pass a more clear state law. And then you could apply it and disqualify Donald Trump. So all 7 justices agree on the legal soundness of a 14th Amendment Section 3 disqualification. The 3 dissenters didn't like either the way that this got into court through Colorado state law or the amount of court that Donald Trump was given, not the actual substantive federal issue. And therefore, this decision is going to get taken up by the Supreme Court. Actually, just read the notice that the Supreme Court has agreed to hear it and is going to set a briefing schedule and probably get this done fairly quickly. But this decision is actually unanimous on the issues that the Supreme Court is going to be looking at, with the possible exception of that procedural due process. It's possible that the U.S. Supreme Court could take that as an out and say, okay, fine, Colorado, you can take Donald Trump off of the ballot, but you got to give him more process than you gave him. And that could be exactly what the U.S. Supreme Court does, hoping that time will solve their problem in actually having to come to a legal conclusion. I'm not sure what's going to happen, but it's possible. And so next, you've got the Supreme Court, U.S. Supreme Court. It's going to decide whether it agrees that the 14th Amendment Section 3 is self-executing, whether it applies to presidents and whether it applies to Trump. And they would be in agreement with all of the justices, the now 8, that have looked at this, if they said yes to those questions. And then they are going to have to decide whether they're going to accept the finding of fact from the trial court that an insurrection occurred and that Donald Trump engaged in it. The Supreme Court's not supposed to change facts as found by a fact finder. And so if I had my money to bet on how the Supreme Court is going to get out of this, they're going to say that the process, they're going to take that second dissenter that the Colorado court had, and they're going to say the process wasn't enough. And they're going to punt. And they're going to say, all right, Colorado, you can do it, but you got to give Donald Trump a full hearing with maybe a jury to determine the facts of an insurrection and the facts of engaging. And honestly, I think that's the right decision. I think that there did need to be more process. When you're trying to decide whether somebody is 35 or 34, you probably don't need a jury. When you're trying to decide whether an insurrection occurred and whether a sitting president at the time, engaged in it, feels like a jury might be the better decision making vehicle. Anyway, just a thought. Let me know how wrong I am in the comments down below. Hit that like button if you haven't already. Subscribe, and just know I really appreciate you. Thanks for coming back.